Welcome to the Arbitration World podcast, in which we focus on significant developments and issues impacting international arbitration. We hope you enjoy this discussion. Please do get in touch with us if you have any questions about this week's episode or any areas you would like us to cover in a future podcast in this series.
Welcome to another in our series of podcasts on issues impacting international commercial and investment arbitration. This podcast is part of our mini-series exploring arbitration in Asia, in which we will be featuring leading figures from the most influential institutions. This presentation is limited in scope as appropriate for a general audience and applicable time constraints. This presentation is not offered as legal advice, which should be obtained only from properly licensed legal professionals on the basis of the specific facts of a given case. I'm joined today by Dr. Fan, the Executive Vice President of the Shanghai Arbitration Commission. Welcome, Dr. Fan. Could I ask you firstly to say a little bit about the cases and the position as in the markets of the Shanghai Arbitration Commission as it stands today in 2023?
Well, Shanghai Arbitration Commission, as a matter of fact, was established in 1995, and currently its caseload represents around 70% of the market share in Shanghai. Namely, it administrates around 6,000 cases per year. So it is one of the leading arbitral institutions in China, and apparently one of the leading arbitral institutions in Shanghai, administrating quite a few cases from its establishment, including a lot of financial cases, construction cases, IP cases, maritime cases, and so on and so forth. So it is probably, I would say, a one-stop shop for dispute resolution for clients in Shanghai, as well as the provinces and regions next to Shanghai.
Could you say, do you collect data in relation to the number of domestic arbitrations, the number of international arbitrations involving parties from outside the PRC?
Yes. In fact, as I mentioned just now, we usually have around 6,000 cases, among which we have around 100 cases involving international parties. Usually we have like 100 to 150 international parties per year. But I have to admit that it is pretty much, based on the quite strict criteria in terms of international elements confirmed according to Chinese law, which provides only when a party is from a foreign jurisdiction or the legal relationship takes place or breached, or this kind of things taking place outside of China, or the subject matter of the contract, for example, is located outside of China, can be considered as an international case. And therefore, if we would include multinational companies which has their subsidiaries in China, that number would be even greater.
Yes, I mean, that's interesting. So really 100 underplays the number of non-Chinese participants that are involved in arbitrations at the Commission. That's very interesting. Could you also say something in relation to the makeup of tribunals? What number of non-PRC nationals do you have any sense of how many are sitting as arbitrators in Commission cases at the moment?
That's a good question. I have to say, on the one hand, we have around 400 international arbitrators on our panel, which is composed of 1,700 plus arbitrators around the world. However, on the other hand, given the fact that we experienced a pandemic over the last couple of years, we didn't really have a lot of international arbitrators sitting on the panel for the cases involving international parties at Shanghai Arbitration Commission. If I'm not mistaken, I think we had around 10 to 20 international arbitrators sitting on the panel over the last couple of years.
Thank you. That's really, really helpful. You mentioned the unfortunate pandemic that obviously affected us all. One dynamic we've seen in the US and in Western Europe is the increasing development of hybrid arbitrations, where people have continued to use technology to minimize the degree to which people have to all come together in the same physical building. What has been your experience at the Shanghai Arbitration Commission? Are remote arbitrations or hybrid arbitrations still popular, or do people tend to come together into the same physical location for a hearing?
I think the pandemic literally expedited the application of hybrid arbitration over the last couple of years. On the one hand, I have to say, not only for hearings to take place in a hybrid form, but also for the filing of the application of the arbitration also takes place in hybrid form, so that I think more than 60% of the cases were filed to Shanghai Arbitration Commission online over I think in 2022 as well as in 2023. And furthermore, in terms of the hearings, yes, absolutely, we are seeing the trend that parties are using more and more frequently the hybrid form for arbitration. In particular, given the fact that Shanghai Arbitration Commission administrates the cases, as I said, 6,000 cases per year, but around 70% of them, in fact, are involving parties from outside of Shanghai. And therefore,
yes,
they are quite keen to use the hybrid form to participate in arbitration instead of all coming to Shanghai, which again will cost them, the cost of travel.
Just looking at costs and timescales, one thing that people considering where they might seek to place their arbitrations, what institutions they would select, often look at the duration of arbitrations under different institutions and the sort of average cost. Do you have any data on approximately what the average duration of an arbitration is under Shanghai Arbitration Commission rules, and roughly what the costs are?
Well, in terms of the cost, I have consulted my colleagues, and I was told that the cost for the administration of arbitration, including the rental of the hearing rooms and so on and so forth, would be around 54,000 Chinese yuan, which I think is around $7,500 US per case. Is the average amount in dispute in Shanghai Arbitration Commission is around $1 million US. So it's
I see.
So it's I think relatively convenient and economic.
Okay, and in terms of the duration, how long cases tend to last from first filing to resolution? I appreciate these are always averages and can be quite misleading, but do you have any data on the average position?
It's around 180 days from the submission of the application towards the issuance of the award.
Wow, that's very quick. Yeah, I know there's been quite a lot of reform and development within the Commission. Could you tell us a little bit about the reform of the rules and any particular unique features of the Shanghai Arbitration Commission rules that you'd like to perhaps draw attention to?
Well, yes, I think there are several points I would like to share with you. Number one is the application of a hybrid form, because as many arbitral institutions, the arbitration rules did not really specify the application of a hybrid form or online arbitration, as the Shanghai Arbitration Commission rules did not, I have to say. So in the new rules, we managed to include that specifically in the arbitration rules. And secondly, we also put in the principles of green arbitration and the smart arbitration, so that we make sure that we are applying environmental rules to encourage people to do more economic, environmental friendly arbitration during our arbitration. And thirdly, transparency. We also encourage our clients to consider the possibility to publish their awards after we eliminate the names of the parties. And finally, as you probably know, China does not allow the ad hoc arbitration in China. However, the arbitration rules of the Shanghai Arbitration Commission has authorized the Shanghai Arbitration Commission to become an appointing authority if the parties eventually decide to apply ad hoc arbitration when the seat is outside of China. So these are pretty much what we had in the new rules.
But this is very interesting. Just touching again on arbitrators and the role of the commission. Do you also administer challenges to arbitrators? If a party challenges an arbitrator, can that be brought to the commission rather than to a court at the seat?
Yes. According to the Chinese law, there are actually several possibilities. One is apparently for the parties to bring the challenge before the arbitral institution for the arbitral institution to decide. However, if the challenge is against the jurisdiction, we nowadays, according to the rules, try to authorize the arbitral tribunal to apply the competence rules to decide its own jurisdiction instead of for the arbitral institution to make such decision. While we have to admit that according to the Chinese law, the parties are still authorized to submit that challenge before the court if the arbitral tribunal or, let's say, the arbitral institution, even if we authorize that to the arbitral tribunal, has not made the decision in terms of the challenge, will accept the challenge and decide, proceed to the hearing. But at least according to the arbitration rules of Shanghai Arbitration Commission, yes, we authorize the arbitral tribunal to decide the challenge of jurisdictions.
Sorry, and challenge to arbitrators themselves if there is a question of lack of independence or an allegation of a lack of independence or impartiality. Is that a challenge that would be brought before a court, or could that be brought before the institution?
That challenge against arbitrator can be brought before the arbitral institution and not necessarily before the court.
Thank you. That's very interesting. One thing that is often a topic of consideration for people outside PRC is the concept of conciliation or mediation in arbitration. Could I ask you a question about that and how the Commission approaches that?
Well, as you know, it is a very well-known tradition and practice in Chinese law. So China's arbitration law does allow this kind of combination of arbitration and conciliation for the arbitrators to wear the conciliators or mediators hat during the proceeding. According to the arbitration rules of Shanghai Arbitration Commission, we encourage the arbitrators not to do that. By on the one hand, we established an ADR center so that parties can refer the case to the ADR center while they suspend the proceeding before the arbitral tribunal. And also, the arbitral tribunal can feel free to refer the case to the ADR center if they do not feel comfortable to mediate the case at the same time and at the same time arbitrate the case. But I have to confess that some of the older arbitrators still get used to the combination of the two proceedings, which we do not forbid because of the law. However, we do encourage them to separate the two different proceedings.
That's fascinating, and I'm sure it will be very interesting to those listening to this podcast from outside the PRC. Just looking forward, if I could ask you to do you have any thoughts or ideas in terms of where things may be going over the next 5 years or so in relation to arbitration in China?
Well, I can see, really a lot of differences between the practice of arbitration in China and outside of China. Because, as you probably know, I had experience with working with ICC. Nowadays, I think for arbitration practices in China, it can be categorized into either luxury products and both luxury products and the fashion products. For luxury products, that's traditional arbitration. We go through all those, complicated procedures, make sure of the due process. Everyone is, paying all the details of the cases, and finally happy with the, fair and, justifiable, results. While for most of the cases, as I mentioned, the Shanghai Arbitration Commission administrates around 6,000 cases. Most of the cases are very small ones. And for those ones, they really need to have a more expedited form to be resolved, so that we can see, some fashion products to be applied to resolve these smaller disputes, so that people do not have to spend more time and more money to see the result. So that I think a blockchain will be used, smart arbitration will be used, and also eventually I think probably AI will be used. These are, two categories of arbitration. However, in addition to that, I'm also seeing the possibility of a wider use of ADR. For example, restructuring of debts, that's fundamentally negotiation between parties. And negotiation apparently also is a form of dispute resolution. Both parties can negotiate to restructure their debts. However, on the other hand, dispute resolution providers can serve as a platform so that they can facilitate or mediate this kind of disputes to help the parties to restructure their debts. So ADR this is only one example that ADR can be used more widely to resolve disputes. Not only, the traditional arbitration, arbitrable disputes, but also, as this example, it was very much relevant to insolvency and bankruptcy, which was not in the scope of the traditional arbitration, but might be resolved by ADR through the ADR department of arbitral institutions. We have just launched a new set of ESG expert determination rules, which can be applied to determine during the development of green technology or this kind of projects. During this kind of projects, always there are some disputes between the parties, the investor and also the developer. Apparently, they want to continue their relationship instead of break the relationship, break the deal. However, they do really need some neutral third party with expertise to determine their disputes, so that they can continue to develop the green technology. So Shanghai Arbitration Commission recently launched this new set of ESG rules, so that this kind of long-term projects can apply this set of rules when smaller disputes takes place during the development, instead of wait for the disputes to become bigger and bigger, and eventually they had to go to a quite long and expensive arbitration, so as to eventually break the relationship and see no outcome of the project.
Why is it that limited to ESG?
Because that's a problem in infrastructure projects in general, isn't it?
Well, it's very much relevant to the market development. Construction, yes, apparently it's very important, but we do have ICC and we have DAAP already. We are not seeing a lot of cases coming to Shanghai Arbitration Commission for this. However, for ESG, that's quite popular in the market, and also Shanghai has been focusing on green technology as well. So we are looking at this market at this moment.
I see. It's something developed in order to be able to attract more business to the Arbitration Commission. That makes a lot of sense.
As a lawyer, we always looking at, from our own perspective, what are the forms of dispute resolution mechanisms. We call them arbitration, mediation, facilitation, and so on and so forth. But eventually, what's more important is not what we think about dispute resolution mechanism. Instead, what's more important is what is needed in the market from the clients. So we need to create new dispute resolution mechanisms to facilitate the needs in the market. And that's an attempt from Shanghai Arbitration Commission to facilitate the needs in the market in Shanghai.
Perhaps, Dr. Fan, you could say something about the degree to which arbitration is supported today in China by the state.
Yes, I would be happy to. Number one, according to China's arbitration law, all the arbitration institutions in China is to be established by the municipal government. The establishment apparently is one of the support we received from the government. And number two, the independence of the arbitration institution is also another support that we received from the government. The government decides not to interfere into any arbitration cases, which is also according to the Chinese arbitration law. And that ensures the independence and the neutrality of arbitral institutions in China. That's another support. And thirdly, the judiciary is also quite supportive for international arbitration. According to the law, the judiciary does not interfere into the merits of the case. Instead, it follows the universal practice, only looking at the procedural issues to decide whether to set up the award or not to enforce the award. And also, we see the judiciary has been quite supportive for international arbitration, recognizing most of the arbitral awards from international arbitral institutions. So I would say we received a lot of support from the government.
Again, looking forward at potential developments, are there any plans for any international offices for the Shanghai Arbitration Commission, or could you tell us a little about those plans?
Yes, Shanghai Arbitration Commission does have a plan to establish its business presence outside of China. Because on the one hand, we understand that the network of the network we need to expand to facilitate and get closer to our potential users. And also, on the other hand, it is a concern in terms of data transfer and protection. And we are not talking about, we are not commenting on any geopolitical issues, but we, as an arbitral institution, need to facilitate the needs in the market and the clients, and make it more convenient for our disputing parties to participate in the arbitration administered by Shanghai Arbitration Commission. So that's the reason why we are considering. And in fact, we are waiting for the final approval from the board for us to establish a business presence outside of China.
That's exciting. Are you able to give us any indication where that presence may be, or is that still to be determined?
It is to be determined.
Thank you very much indeed. That's very very interesting to learn of that interesting development for arbitration in China and the subsequent growth of the Arbitration Commission.
It's quite important that Chinese arbitration institutions and also for international arbitration institutions to find a way out to facilitate the current difficulties that our disputing parties, our clients are facing. I mean, eventually we really need to resolve the disputes in the commercial and business arena. Otherwise, it's becoming even more difficult for all of us to live together in this only world.
Well, that's a very positive message to end on. Thank you very much for your time.
Thank you so much for your time as well.
Thank you for listening to this episode of Arbitration World Podcast. To listen to past episodes and receive notices for new episodes, subscribe by searching Hub Talks, that's HUB Talks, in your favorite podcast app. We hope you will join us next time for further discussions on hot topics and significant developments in international arbitration from around the globe.